This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about a blank space on a contingency fee agreement and how that blank space made the agreement totally unenforceable because it was evidence that there was no meeting of minds and therefore no contract. Attorney Richard Schicker sued a former client, Brandi Cady, seeking payment for attorney's fees under a contingency fee agreement. The district court dismissed Schicker's complaint, finding that there had been no meeting of the minds during the formation of the agreement, and thus there was no enforceable contract. In Richard Schicker v. Brandi Cady, the Court of Appeals of Nebraska on May 7, 2024, explained what is needed to form a viable and enforceable contract. Attorney Schicker had sued Cady, alleging that he had entered into a written contract with Cady whereby Schicker was to represent Cady in a claim against Lincoln Financial Group for life insurance benefits owing to Cady due to the death of her husband. LFG later agreed to pay Cady the full policy amount, and the complaint sought judgment against Cady for 40% of that amount, plus any cost incurred by Schicker. Cady testified that at the time of her husband's death, the couple had 3 children and that she immediately attempted to collect his life insurance benefits. Cady called Schicker's law office and testified that she called to inquire about a personal injury claim as she had heard from community members that the highway where her husband was killed had been deemed dangerous and was soon to be under construction. A contingency fee agreement between Cady and Schicker was executed. The agreement was entered into evidence and stated that Schicker was to be paid 40% of the amount recovered or settled on behalf of Cady. In the first paragraph of the fee agreement is the statement, "Client may have a claim against," and then a blank spot. And the section is later filled in with the words Lincoln Financial. Cady did not recall Lincoln Financial appearing anywhere in the fee agreement at the time she signed it. On October 2, 2017, Cady sent Schicker an email with the subject line, quote, "cancellation of services." The email stated, quote, "At this time, I have a family member who is going to handle insurance claims for Lincoln Financial. I do still want to retain your firm for possible case regarding the accident itself," close quote. On October 2, 2017, the parties canceled their fee agreement. Another copy of the fee agreement was entered into evidence, which included the additional notation, "Agreement canceled as of 10/2/2017," close quote. At the bottom of the form, there was Schicker's signature below that notation. Cady testified that she had done all of the work to collect the insurance claim herself. Glenda, a representative of LFG, testified that the only phone call she had with Schicker occurred after the claim was paid and he was attempting to collect attorney's fees from LFG. The district court dismissed Schicker's complaint. The blank space in the fee agreement established that the actual fee agreement was not completed. In addition, the district court found that Schicker lacked credibility because his itemized bill said that he spent 58.6 hours of billable time over the course of only 12 days working towards the collection of the insurance benefit, even though he had never contacted the insurance company. the district court concluded that no agreement had been formed between Schicker and Cady because there was no meeting of the minds as elicited by the testimony at trial. A party seeking to enforce a contract has the burden of establishing the existence of a valid, legally enforceable contract. To create a contract, there must be both an offer and an acceptance. There must also be a meeting of the minds or a binding mutual understanding between the parties to the contract. It is a fundamental rule of law that in order to be a binding agreement, there must be definite and certain agreement as to the terms and requirements of the contract. It must identify the subject matter and spell out the essential commitments and agreements with respect thereto. Because a meeting of the minds had not occurred, there existed no valid enforceable contract between the parties. The district court did not err in so finding, and the Court of Appeals affirmed. Since there was never a meeting of the parties' minds concerning the claims at issue in the contingency fee agreement, there was no contract that was enforceable. In my opinion, signing a contract where the subject of the contract is left blank is an error a first-year law student would never make. Heck, it's an error that no high school graduate would make. And should any licensed attorney like Attorney Schicker, it was a strange and unbelievable error. He had the unmitigated gall to sue a client for fees he claimed he earned to gain the benefits of a life insurance policy, claiming to spend more than 4 hours a day for 12 straight days on the subject, although he never contacted the insurer before they had already paid. He never obtained a valid contingency fee agreement because the key element was left blank when the client signed it. Amateur actions by a lawyer, such as those made by Attorney Schicker, should never be enforced, and the Court of Appeal refused to do so. In my opinion, and in regard to this video, it was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you will gain access to the more than 4,750 blog postings. Please tell your friends and colleagues about the blog and these videos so that they too can subscribe. They're all free. And if you're interested in obtaining information about insurance, insurance claims, insurance fraud, and insurance law that is more detailed than is possible in a blog, please consider subscribing for a very small fee to my Substack publication. Thank you for your attention.